The Supreme Court had stated that suitability of a candidate cleared by the Supreme Court Collegium for appointment as a judge in a constitutional court cannot be subject of judicial review, while pronouncing reasons for dismissing petitions which claimed that Advocate Victoria Gowrie was ineligible for appointment as an additional judge of the Madras High Court. The verdict came on Friday 10, 2023. However, this is not the first incident that a judge's appointment has been challenged in Supreme Court. In 1992 also, the SC has quashed the appointment of K.N. Srivastava as a judge of Guwahati High Court before he could take oath as a judge. The petitioner in the case of Victoria Gowrie also cited the 1992 case but of no avail. On January 17, 2023, the Supreme Court Collegium recommended Victoria Gowrie elevation to the High Court. However, her appointment raised controversy when lawyers from the Madras High Court wrote to the Chief Justice of India, D.Y. Chandrachud, seeking to recall the recommendation. The letter drew the Collegium's attention to social media posts of Advocate Victoria Gowrie in 2018, which petitioner allegedly amounted to hate speeches against Christians and Muslims. What the bench said: Advocate Victoria Gowrie's appointment was notified by the High Court Collegium on February 6, 2023. She took oath as an additional judge in the Madras High Court on February 7, 2023. The special bench of Justice Sanjeev Khanna and B.R. Gawai stated that a judge's pledge and duty transcended religious, linguistic, regional or sanctional diversities. As an additional judge, she would be under the daily scrutiny from lawyers, litigants, and the public. The bench also said that while exercising the power of judicial review, it could not issue a writ of certiorari. Doing so would violate the law, as it would amount to evaluating and substituting the decision of the Collegium with individual or personal opinion of the suitability and merits of the person. Refusing to interfere with Victoria Gowrie's appointment, the bench said that the political affiliation of a candidate or public expression of their view did not impact their work as a judge. The 1992 case. In 1992 case, the controversy was around the appointment of K.N. Srivastava as judge of Guwahati High Court. Srivastava's appointment was notified by the President of India on October 15, 1991. However, he had not taken the oath as a judge yet. The Supreme Court was skeptical about his appointment, as it would violate Article 217 of the Constitution, which states that a person would be qualified to be appointed as a High Court judge only if he has held a judicial office in India for or has practiced as a High Court lawyer for at least 10 years. A lawyer challenged Srivastava's appointment in the Guwahati High Court because Srivastava had neither practiced as an advocate for 10 years nor held any judicial office. At the time of his recommendation, he was working as the legal remembrancer and secretary with the Law and Judicial Department of the Mizoram government. Later, the petition was transferred to the Supreme Court. Though there were corruption allegations against Srivastava as well, the Supreme Court restricted its judgment to the issue of his eligibility for appointment to the High Court. Ultimately, the Supreme Court declared that Srivastava was, in fact, not eligible to be appointed as a High Court judge and quashed his appointment. It was for the first time in India after independence that in 1992, the Supreme Court was seized of a situation when the court had to determine the eligibility of a person appointed as a judge of High Court by the President of India. The petitioners in Gowrie's case also cited Srivastava's judgment to show that the Supreme Court could set aside the appointment of a judge even when an appointed order has been issued. However, Srivastava's case was decided before the Collegium system was crystallized by the second judge's case in 1993 and third judge's case in 1998. Hence, it was the first such intervention against the recommendations made by the Supreme Court Collegium. Srivastava's case versus Gauri's case. The Gauri's case did not challenge her eligibility to be appointed as a judge in High Court. The Supreme Court judgment on Gauri referred to the past judgment which differentiated between the eligibility of a candidate for evaluation and the evaluation of the worth and merit of a candidate. The court also pointed out that it could look into the eligibility of a candidate, but the question whether a person is fit to be appointed as a judge involves the aspect of suitability which stands excluded from the purview of judicial review. In the case of Gauri, the concerns raised were pertaining to her suitability and not her eligibility. The SC also stated that the 1992 judgment was passed in a case relating to the eligibility of a person who was not qualified to and eligible for the post. Appointment of judges in India, Centre versus Collegium. Collegium is a system under which appointments and transfers of judges are decided by a forum of Chief Justice of India and 4 senior-most judges of the Supreme Court. It has no place in the Indian Constitution. The Collegium of Supreme Court comprises 5 senior judges including the Chief Justice of India. They consider the elevation of Chief Justice or judges of High Court to Supreme Court, elevation of judges of High Courts as Chief Justice, and elevation of judges. In case of difference of opinion, the majority view prevails. Since Constitution mandates that consultation with the Chief Justice of India is necessary for appointments to judiciary, the Collegium model evolved. While there is no mention about the Collegium in the Constitution of India, it has evolved through the Supreme Courts, collectively known as the 3 judges cases. Number 1, S.P. Gupta versus Union of India, 1981, also known as the Judges Transfer Case. Number 2, Supreme Court Advocates on Record Association versus Union of India, 1993. Number 3, in Re Special Reference 1 of 1998. Appointment of judges to the Supreme Court. According to the Article 124 of the Constitution, every judge of the Supreme Court shall be appointed by the President after consultation with such of the judges of the Supreme Court and of the High Courts in the states as the President may deem necessary for the purpose and shall hold office until he attains the age of 65 years. In the case of appointment of judge other than the Chief Justice of India, the Chief Justice of India shall always be consulted. Right now, the Collegium consists of 6 judges instead of 5 because none of the 4 senior most judges would become the next Chief Justice of India. It is mandatory for the next Chief Justice of India to be a part of Collegium. Justice Sanjeev Khanna is therefore the 6th member of the Collegium. Right now, who would succeed the present Chief Justice of India, D.Y. Chandrachud, as the next Chief Justice of India? The recommendations by the Collegium for the Supreme Court could be of 2 types. Number 1, when High Court judges are to be elevated to the Supreme Court, and 2, when senior lawyers are directly appointed as Supreme Court judges. For appointment to the High Courts, the Supreme Court Collegium would comprise only 3 judges including the Chief Justice of India and 2 senior most judges. For appointment of judges to the Supreme Court, the Collegium comprises 5 judges. Like the Supreme Court, the High Courts too have a Collegium headed by Chief Justice of High Court and 2 senior-most judges as members. The High Court Collegium sends its recommendation regarding all judicial appointments only to the Supreme Court Collegium. Appointment of judges to the High Court. For appointment or elevations of judges, the High Court Chief Justice along with 2 senior-most judges makes recommendation to the state government. The state government in turn sends the name to the centre with its input. On the directions of the centre, the Intelligence Bureau conducts the background checks and sends its report to Supreme Court Collegium, which then recommends the name to the centre for appointment. The centre has the right to accept or return the file back to the Collegium for reconsideration. Collegium has the right to reiterate the names sent back by the centre for reconsideration. In that case, the centre is bound to appoint the candidate.